how do we shut this claim down? This thing's been open 2 years. How do we arrive at settlement? And so I think, you know, it can be kind of typical for a lot of cookie cutter approaches in this industry. And so what we'd like to tailor today's conversation is how do we arrive at, you know, outside the box opportunities to arrive at resolution, to shut claims down, and to almost kind of change the mindset to constantly be thinking about closures and resolutions, just settlement opportunities. Yes. So those handsome gentlemen are the guys that are right in front of you today. And so again, kind of reassessing is the importance of settling early. And I know that we kind of set this up as an opportunity to kind of chronologically detail sort of each phase in the process and how we can creatively arrive at settlement at each stage. And so the first one is you get notice of a claim or you get notice of representation. And so in some instances, it might make sense to shut a claim down and settle early. And so I know you had a couple of you know, items that you outlined. I'll go and let you kick these couple off.
Absolutely. So if an employer or an insurance carrier obtains a new application for adjudication of claim, and it may be first notice of the claim comes through that application, one of your first opportunities to settle before any costs are incurred or minimal costs have been incurred are during the delay period. And if an injured worker is treating somewhere outside of a medical provider network and you are in that 90-day delay period, you have the opportunity to have your defense counsel file for an expedited hearing and address the non-MPN treatment and assert medical control through the MPN. At that hearing, it's always a good opportunity to try to discuss preemptive resolution with opposing counsel and see if you're able to resolve the case at that time. Of course, it's going to depend on the mechanism of injury, the factual issues with the case, and what your opposing counsel wants to do with the case and who your opposing counsel is. The benefit of settling at an expedited hearing is you haven't incurred any deposition fees. Most likely you've incurred minimal medical treatment fees, and there hasn't been much in the way of discovery or medical legal evaluations.
So to piggyback on that, a scenario could be we get a post-termination claim, right? Pretty standard in California, and it's in delay process, right? And so you determine, again, you wanted to establish medical control. You file for the hearing. That kind of buys you some time, call it 30, 45 days maybe, for us to get all parties together at the board. And in this discovery process, you know, we should have discovered at least whether or not we have any legitimate exposure. Obviously, records, or could be a lot of things that are still pending the deposition. But if you find out enough early in the stages that this is one that you want to identify for settlement, that's the perfect opportunity for all the reasons that you mentioned. It's early in the process. As long as the number is agreeable to all parties, use this as an opportunity to get everyone together. Many times it's the first time that you would have had a physical interaction with the council. And so it's, look, this is where we're at, and this is why we want to get it, you know, shut down.
Absolutely. And a lot of times when you're dealing with a high volume applicant firm, they are not going to be accessible via telephone or via email. A lot of times they're unresponsive. And so this kind of forces their hand, gets them to the board, gets the applicant to the board, and you can have some meaningful discussions. In preparation for this, if you're going to have your defense attorney do this, I would definitely recommend getting an ISO search. It's going to show any past workers' compensation claims that the applicant may have had, any motor vehicle accidents with bodily injury, and any general liability claims. Also, depending on what you find on the ISO reports, we would immediately want to subpoena any relevant records and use anything that you can put together as leverage to maximize this opportunity.
And so, along the same lines, let's say that they're not treating outside the medical provider network, but there's an issue with either factual, medical, and it sounds like you're addressing here a similar process. File for priority conference on AOE, COE, and use it similarly as an opportunity to settle while there's still issues in dispute.
Definitely. So with AOE, COE, which means the injury arose out of employment and was caused by employment, typically what you want to do is get all of your ducks in a row and definitely confer with the insured or with your employer. Get all of the relevant information that you need, whether it's employer witness statements, supervisor statements, any possible video footage of the injury when it occurred. And then if you do feel that you have a strong defense, immediately file for that priority conference. In looking at any claim, before you start to navigate the medical legal process and go to a panel QME or go to an AME and start traveling down that avenue, you always want to look at your legal and factual defenses first, because there may not even be a reason to dispute something on a medical basis if you can dispute it on a legal defense or a factual defense. And so then we get it to an AOE COE priority conference. The applicant attorney has to be prepared to go to trial on that issue. And so now you're in a situation where the applicant has to be ready to go to court, to get on the stand and testify. And most times, if you're going to take this step, the defense attorney is going to have employer witnesses available too, and they'll be at the hearing. All of this kind of creates the perfect scenario to leverage the applicant and have them realize how serious this is, and that you will fully litigate the issue and you can effectuate settlement under those circumstances.
And in the event that you can't arrive at a settlement because they're either being unreasonable, they're unprepared, or the judge allows them to maybe go and request a panel. For whatever reason, what it does though is definitely sends a message to the applicant attorney that we're digging in, right? That we feel that this is a winnable case in many situations, and that this isn't going to be one of those rollover claims where you're going to be able to work it up. It helps to also, like you said, send a message if you can't settle.
Absolutely.
Right? So the other one on the list is assuming that this isn't an opportunity, or we simply can't agree. Early in the discovery process, at some point, in most cases, we're going to want to pursue a deposition. And I think that is, oftentimes an underutilized opportunity for settlement. So why don't you kind of talk about, not just the benefits, but how we go about preparing to, arrive at resolution at depo.
Okay. So now we've gone through those initial prongs and we're continuing the discovery process. The deposition is a critical point in every case because you do have this one opportunity to thoroughly question the injured worker about any prior injuries they've had, any pre-existing medical issues they may have had, their employment history, concurrent employment, anything that could give us a basis for apportionment or to dispute causation. And typically, we at our firm always like to use the deposition because it really provides you with an opportunity to get the case resolved. Again, it's one of those situations where you have all of the parties present. The applicant will be there, their attorney will be there. Oftentimes they may bring a family member and you can really sit down, begin to question them. A lot of times if you've done your due diligence as a defense attorney and you have your subpoenaed records and you have any records or witness statements to dispute the applicant's injury or the mechanism of injury or to show that they've had prior injuries, perhaps they're a professional litigant, you can kind of show your hand, show them all of the information that you have, and a lot of times that'll induce them to want to proceed with a settlement. Definitely a key point with that is the applicant attorneys on the other side are often looking at their Labor Code 5710 fees, which is deposition fees that they get. And so you want the insured or the employer to be a little bit flexible with that because a lot of times that is what will incentivize the applicant attorney to agree or to promote settlement to their client.
So, hey, we're willing to pay you 5710 fees, even if it doesn't move forward with the deposition.
Exactly. So, for example, if you have an attorney that is coming out from the Valley or possibly Van Nuys area to Orange County, a lot of times your typical itemization for 5710 fees would be 3 hours of travel, an hour of preparation time, and maybe 2 hours of deposition time at $350 to $400 per hour. You may be able to pre-negotiate 4 hours of fees, which is still a cost benefit and reduction for the insured, and still it'll facilitate them to want to move forward with a settlement and not do the full deposition.
I'd say it's probably the most important part, right? Because the applicant attorney is the one driving the decision anyways. And so if they get paid, they're more likely to settle the thing rather than drag it out any further, right? I mean, incentivize them to to shut it down. All right, I get paid and I don't have to do any more work. Okay.
Exactly. And the thing is, with workers' compensation in Southern California, throughout California, the applicant attorney fee at the time of case resolution is 15%, which is very low compared to civil arena, which is 33 to 40%. So even on a $50,000 case, an applicant attorney is going to walk away with $7,500 in fees. And if they're able to obtain another $1,500 or $2,000 at a deposition setting, they've increased their fees by almost 20%.
Good point. So help me understand too, how, as far as the negotiation when you're at the depot, you show up, do you prefer to negotiate in lieu of the deposition? In other words, look, like you kind of mentioned, we have a pretty good hand here. We've got some settlement authority in lieu of the deposition. And then you tell them, look, if they crash and burn like we think they're going to, this isn't going to be on the table. Or kind of walk me through the negotiations at the deposition.
Absolutely.
Secret sauce.
Yeah.
Giving it away.
So my particular deposition style is typically at the start of any case, you can usually, if you have some medical records, determine a case valuation. So for example, if an injured worker has a lumbar sprain strain, we can go to the AMA guides. We can assume they may be a DRE category 2 and assume that will be 5 to 8%, look at their occupation code and their age, and come up with a baseline permanent disability value. And then also based on their age and possible treatment modalities, come up with a future medical care evaluation and use that for settlement purposes. And so when the applicant attorney typically finishes preparation with the applicant, and they'll spend about 45 minutes to an hour talking to their client, I'll pull the applicant attorney into my office and say, look, these are the facts of the case. This is the mechanism of injury. This is what we have as far as diagnostic testing or medical reports this far. And this is what the case is valued at this point, rather than the carrier or employer continuing to incur costs at a discount today. They're willing to try to settle this for this amount and then have them talk to their clients. Of course, you're not going to usually offer up your highest value up front. You're going to start at a lower figure and go back and forth from there accordingly.
Got it. So I like this slide. And from an employer's perspective, I think that this is the question that I would ask employers. That what's on this screen has nothing to do with law, right? Schedule it as soon as possible to a little bit of an intimidation that we're willing to take this serious, right? So schedule the deposition as soon as possible. Be flexible with the 5710 fees, right? That has nothing to do with law. Just, hey, we'll pay you if you go away, right? Mr. Attorney, if you talk your client into settling, we'll make sure that you get paid. And the third one, have an employer representative present to not intimidate, but to make sure that the injured worker, yeah, exactly, the injured worker doesn't exaggerate too much on the injuries or what happened and so forth, right? So from an employer's perspective, when I'm looking to hire an attorney, is it 50-50 technical law ability and just like street smarts, kind of tips or tricks of the trade that you want to look for, or do you want the super technical law, well-balanced attorney, right? Got it. Does that make sense?
Absolutely.
Somebody on the technical side, or somebody on the street smart side, or somebody in the middle. How much of your job is actually on the law side, and how much of it is just dealing with people?
So it's always going to depend on like the technicality of the case. There's definitely some cases in which you need a very strong litigator that will do the case law research, and you may be dealing with a specific legal or medical issue that is going to be very law intensive. And in those scenarios, the negotiation component of it doesn't play in as much, because most likely you're in for the long haul and you're fully going to litigate the case. When you're dealing with your like denied claim, a post-termination claim, something that's with an applicant mill, then a person that has good personal relationships with the opposing counsel or has good communication skills and a negotiation style, that's going to play a lot more importance in those type of cases. And so I think it's always extremely relevant for the defense attorneys to have open lines of communication with opposing counsel. That doesn't diminish their advocacy for the employer or for the insured, but workers' comp specifically is very relationship based between applicant and defense attorneys, because we see each other on a weekly basis. Whereas in civil court, you may not see opposing counsel on another matter for years. That's very much the industry standard. So in our industry, those personal relationships and the ability to communicate effectively is very important. I think also if you've litigated against an attorney before and they know that you'll fully go forward with the matter, that you come prepared to your hearings, that you come prepared to your depositions, it sends a message to them right away when they show up at your office that you're either going to go to bat or you're going to reach a resolution. And so that helps facilitate things as well.
That's a good point. Yeah, Josh and I agree with that too. Josh is extremely technical, and I'm less.
Well, I think it's a different approach, right?
It just depends.
It's kind of like a mix, like what you said, right? They get it done about you, and then there's the technical ability.
Right.
And at some point, when you're done, litigating the technical piece, you need to get it done about you to be able to call, facilitate resolution, and be able to whittle down those numbers and be able to use those arguments to get the number that ultimately your client is going to be okay with.
Absolutely.
So if I was an employer, I'd look for somebody that has both, or at least a firm that has both. Right?
Yeah.
So I'm sure if you get a filing and it's going to trial, you're going to discuss with your partners, all right, who's the best litigator,
100%.
and maybe you quarterback this.
For us personally, we definitely try to look at a new file when it comes in, assign it to an attorney that's most familiar with the jurisdiction, most familiar with the opposing counsel, and has a certain skill set depending on the facts that come in with that case. And that's our strategy, which has led to a really good closure rate.
Sorry to sidetrack.
No, it's good. That's good points. So the next is, if we're not able to settle at the deposition, which isn't always the case, but in the event that we move forward with treatment and we finally get the MMI report, the maximum medical improvement report, well, now we've got a basis, we should at least, for bringing something towards resolution. We should know what the impairment looks like, what future medical care looks like, and so we can start to formulate some numbers. Doesn't always mean settlement is the next step. So let's go through a couple of the items that you outlined here as far as how to move forward with settlement once you get that report.
Real quick, for the HR managers out there that aren't risk managers or attorneys, MMI is
maximum medical improvement. Yes, which is essentially permanent stationary. They kind of use those words interchangeably. You either reach to a pre-injury status or a plateau in which the doctor issues a final report that we can base settlement on.
right. Report saying that they're fine. Here's my final findings.
It may not be that they're fine, but they have either a level of disability
Okay.
or whether they
The
can
result
return to work. Yes,
Here's the conclusion. Final
absolutely.
report.
So a lot of times now you've completed discovery. You've gone through medical treatment, you've gone through your deposition, you've compiled everything that you need, and the applicant has either treated with their primary treating physician or has gone to a panel QME or AME evaluation. And as we said earlier, some MMI report has been issued. This is a key and critical time when you can also settle the case. Once again, a lot of times an applicant attorney will argue that pursuant to Labor Code 4061I, you have to have both an MMI report from the primary treating physician and the panel QME doctor. That is not necessarily true. You can definitely try to settle on one of those reports, and the injured worker does have the option to waive going to a medical legal evaluation or waive a final report from their own primary treating physician. So let's say you do have an MMI report from the primary treating physician doctor. You can have your defense attorney immediately file for a mandatory settlement conference, assuming that there are not pending issues in other specialties or any special circumstances if we're dealing solely with like an orthopedic type of case, and try to get all the parties to the board and utilize that report for settlement. The counter to that would be a lot of times someone say like, well, what if the applicant's treated with on a lien basis, self-procured, with a very liberal doctor, and so you have an MMI report with inflated or exaggerated permanent disability value. You can still file for the hearing, and basically what you do is argue a diminished version of that report on the defense side and say, look, realistically, you're saying the applicant has a permanent disability for the back of 13%. And in reality, we think if we go to a panel QME doctor, this is only going to come in at 5 to 8%. You're valuing future medical care at $50,000. When we look at what care the applicant has had so far, we only value it at $10,000. Therefore, we're willing to make a settlement today at this MSC for $15,000, $20,000.
Now, to me, the upside is a settlement. You get a report you want, you file for a hearing, you get everybody together. The upside is you can settle. The downside is it doesn't settle, but that's okay. Now you can move the cross-ex or whatever the next couple of steps are, additional panels. But if you don't file for the hearing, the answer is always going to be no, right? If you're not able to get there. So again, we're looking at creative opportunities to shut this down. And so this is definitely an aggressive stance, one that I support, especially if you have settlement authority. Then I think it's worth attempting this, because again, if it doesn't happen, then you move right to your plan B, which is additional discovery, more panels, or clarification on the reports by way of supplementals or cross-ex. But either way, I think we all agree that there's value in having these discussions and getting everyone together, right?
100%.
I'm taking every opportunity to try to settle it.
Yes.
Right?
Yes.
Absolutely.
And we always say it, if you don't ask, the answer is
Always no.
always no.
Yep.
If you don't ask a question, you're not going to settle it.
Yep.
So,
And another version of this is you don't necessarily have to even file for a hearing. If you do have open lines of communication with opposing counsel, you can set an informal settlement conference. That'll save you some defense attorney fee costs. I know you don't like to pay my bills, but we can set up an informal meet at the applicant attorney's office. Again, incentivize with maybe 2 hours of 5710 fees. And again, they look at that as padding. It's additional revenue for their office. They'll be willing to meet you, which is one thing. Based on high volume, they're not going to set aside the time unless there's some financial incentive for them. And then once you're at the office, if you do reach an agreement, a way to offset that for the insured or for the employer is to have the applicant attorney walk through the settlement. And then you're not incurring the defense attorney fee costs on that. A lot of times the applicant attorneys work at specific boards. They are very venue specific. So if they're always at the Long Beach board or at the Marina del Rey board, it makes sense for them to walk it through and to save you some additional litigation expenses.
so again, from the employer's perspective, why do you have to set an informal settlement conference and make it official and type a report and show up at their place? Why don't you just call them? Or it does it go back to what you said earlier, that they're not always available by phone, not always available by email, probably never even met the applicant, that type of deal. Or can you just call them? Just make it very informal. You don't need to write anything down, just call them real quick.
Yeah, you can always, that's always where you want to start, is start off with a call, leave a message. A lot of times if it's a larger applicant firm, they may have hearing representatives or specific people that are designated to handle settlements. Leave a message for that person. Try to get an email contact if you can. If you have all your benefit printouts and all the information you need regarding EDD, any temporary disability overpayments, any child support liens, or any Medicare or Social Security disability issues, you can pre-draft the compromise and release documents and any other documents you need. Just send them over via email, and sometimes you will get a hit that way. If you don't, then that's when you try to reach out to them, whether you're in court, you see opposing counsel, and say, hey, can we set up an informal settlement at your office? My client's willing to issue 2 hours of fees. If you're willing to carve out that time for us, then maybe we can get this one done.
That was a great point that you brought up, that you kind of mentioned and you moved on to something else. But when you said actually drafting the settlement document and sending them to the applicant attorney, I think that's huge, because in many cases there's just figuratively these numbers being thrown out, but when they see it on an actual compromise and release document, then I think that speaks a lot more volume. And now it's like, well, I can easily call my client and relay, because I'm looking at the document.
One signature cash shows up, right?
If you come in, if you come into the office tomorrow, we can sign it, we can be done with it, that kind of thing.
Makes it real.
Yeah, so I think that's a really, we didn't include that one on the slide, but I think that is a good strategy too. Showing up to the hearing with it already pre-filled out too.
Oh,
that
for
can
sure.
be big also.
100%. And if I do send an email to an opposing counsel with settlement documents, it is a detailed email, and it'll break down my rating strings, what I value the permanent disability at, and what I foresee the future medical care to be at. That way they know we're making a serious offer. They know it's just not a random number that we drew out of the dark. A lot of times you have to assume that these applicant attorneys are working on high volume. So if they're handling 1,000 cases for each person, they don't have a lot of time to go through, do the permanent disability rating strings, to do the future medical care evaluation. So now you've pretty much done all the legwork for them. You've drafted the documents, you've given them the PD rating string, you've given them the future medical care evaluation. It's just a matter of them calling the injured worker, having them come into their office and signing the documents.
So on that tip, and I know we've already moved on to the next slide, but on that point, and this is one, it wasn't a slide necessarily, but in creative settlement opportunities is when you got the number, I found that when you're calling plaintiff counsel or applicant attorney and you're making those calls, they go right to voicemail sometimes, right? Or sometimes it goes to the reception. What I found is that when you use the word settlement authority, there's a lot better chance of you getting patched through to that person. If you're just, hey, I need to talk to so-and-so attorney, it's like the other 200 calls that they're getting a day. You're saying, I'm calling about resolution, I'm calling about settlement, I'm calling, I've got money. You're much more willing to get, or they're much more willing to send you and patch you through to the person that actually going to be on the other end.
Okay, so is it important for the self-insured? It would be more, I guess it would be easier because you can just ask your client for settlement authority. But say the clients that have guaranteed cost programs, is it important to have settlement authority throughout this entire process? Obviously, it'll change throughout the process, but right, for the first deposition, you have X, right? And then 2 months go by and another event happens and now you have Y. Is it important for the attorney to have settlement authority before he leaves his office?
Absolutely.
Or at least somebody to call, whether it's the broker or the examiner or your client directly, if it's like a or something,
I mean, ideally, you never want to be calling your client the day of a hearing or the day of a deposition discussing settlement authority. It's something that you should have sent to them, weeks in advance of that with your valuations. And you're totally right. Like at each point of the case, the valuation is going to be different. So of course, at the origin of the case, the settlement value is typically going to be a lot less as you've gone through the discovery process and medical treatment, and you may have some medical justification to supplant like a higher demand, then of course the case value would go up. But that's why it's so important that the defense attorney regularly communicate, especially when you have key events, like you have a PTP MMI report come in, that's primary treating physician, or if you have a panel QME report come in, or if there's been a drastic change in the case. So sometimes an applicant or injured worker will have comorbidities that could be something like diabetes, or they have a heart condition, and all of a sudden there's been a huge change in status because of the underlying condition that's non-industrial, which may affect the case value, and you need to make your client aware of that because a lot of times it will affect reserves and the other medical treatment that may be necessary.
We always say the longer the claim stays open, the more expensive it's going to get. That's a good general rule of thumb. It's not always the case. You can take a trial and take nothing, but very, very rare. And so it makes these settlement opportunities that much more important. Right? That's the whole reason we're even talking about it, is because if you can settle early and often, you're going to save yourself a lot of money depending on your volume of claims.
So I think what you just mentioned there is critically important, having settlement authority. The only way that we can engage in these creative settlement opportunities is if you have a number.
Right.
So yes, it's absolutely vital that we're constantly communicating along with any change, any material changes in the claim. Those need to be relayed. But at the same time, if you're at a deposition and we think we've got 5,000 settlement authority because we've got a very strong case, if all of a sudden they list 2 or 3 witnesses that we never heard of or coworkers that they specifically told injuries to, now you might need a timeout. I need to call my client, hey, they just mentioned this, this, and this. They sounded very credible, very believable. They said it with conviction. This completely changes maybe our defenses. It completely just obliterates the defense. And now having that open line of communication on the fly to say, look, they're here. We're all here together. If we get an updated number, maybe that number goes from 5 to 15, let's just say, having them on a text or being able to call them on their cell, that's another creative way to arrive at that. Although the developments have changed, it's almost as important to have that person handy on the fly to make those calls, as they come up.
Absolutely. But it's important to calendar these dates.
Yeah.
As well, if you're the employer.
So let's switch gears a little bit because we're on the next slide and we talked about getting to the hearing and, maybe applicant attorney hitting us with some new allegations or new medical, treatment reports, maybe amending the application to include other body parts. So this is a very creative way to still settle a claim that maybe started out as an orthopedic claim with other body parts. So why don't you jump into that one?
Okay. So there's definitely be certain scenarios where you will have an injured worker who is not willing to resign their employment, and they may still be an employee. They may actually be a good employee that you don't want to lose. And so ultimately, the case does not lend itself to a full compromise and release, which essentially resolves all issues. And the majority of the time, the employer would like resignation from the injured worker in those type of settlements. When you can't do that, and let's say you have a combination of a legitimate orthopedic injury, but the applicant has gone on and obtained representation, and they've added things like sleep and psych and internal, a way that you can resolve as much liability as possible for as little cost as possible is to enter into a stipulated award for the accepted orthopedic body part. Let's say it's a back injury or a leg injury with a set permanent disability percentage. And then the applicant would have open future medical care for that one body part. And then separate and apart from that agreement, you would do a CNR, compromise and release, of the denied body parts. So let's say you're buying out the internal, it could be heart conditions, psych and sleep, and then you use the CNR for a nominal sum, assuming that there's no substantial evidence to support those claims, $5,000, $10,000, you buy out the denied claims, and those can no longer be litigated. They are wrapped up in that claim, and then you have the set amount for the orthopedic body part.
I didn't know that you could do that.
And that would be a strategic decision that you would make in trying to enter into an agreement without having to litigate and all the additional costs associated with going to panels for each of those specialties.
So because you stipped part of it, do they stay on the books as far as being an employee?
They would still be an employee. They're actively assuming they're still working there. Another scenario that I've had this same exact thing in is...
So you can't have a voluntary resignation in this scenario?
You cannot.
Okay.
No. So if
you step anything, they have to stay on the books.
I mean, technically they could resign, but most of the time the reason you're entering into a STIP is because they either don't want to resign or they want to leave their future medical care open. So it would be very case dependent. But another example of this is I did have an injured worker who worked for an aerospace company for 34 years and had his allegation was that he had noxious fume exposure, and he did have a legitimate back injury. This was an accepted back claim. Before we got subbed in the file, they had treated with an AME and already had PD and future medical care assigned for the low back. Eventually the injured worker became represented and filed for brain condition, for central nervous system, internal medicine, and the applicant's condition had degraded to the point where he was in a wheelchair, he could no longer walk or talk, and would eventually need to be fed, and he was going to have home care, attendant care for the rest of his life. With 34 years of employment, there's a serious risk on the continuous trauma. There was definitely solvent exposure, and there was a risk that we wouldn't be able to produce the material data safety sheets over that 34-year period. And then in addition to that, there was just millions of dollars of exposure if this gentleman was going to need care for the rest of his life. So we subpoenaed the Kaiser records from the individual, and it showed about 17 years of history, showed how this condition started, and showed that the doctors at Kaiser could not identify what was the cause. So they didn't have a medical term for it. They weren't sure what was the cause of it. And ultimately, this is something that was going to go to a medical legal evaluation, possibly a trier of fact on those issues. It was time sensitive for the opposing counsel and for the injured worker because it was likely that he may die within like the next year or two. And so creatively, we came up with a settlement solution, which was to stipulate the back injury, and it was like 7%. And then we ended up buying out all of the denied body parts for $150,000, which would seem like a lot. Like a lot of employers would say, wow, I do not want to pay that much money up front. But the risk was that if this was found industrial and the employer was on the hook for all of his attendant care throughout the remaining portion of his life, you're looking at $1 million or more in exposure, also the possibility of a death claim. And so now, by settling out that denied body parts and including very strong language referencing the Kaiser records, it allows us to fight any liens and say, look, this is always denied. The Kaiser records do not show industrial causation. There's no other basis to establish that this is related to the applicant's employment. The applicant was already on Social Security disability, so that raises the second prong. And this is a much more complicated scenario, but after we had stiffed the case on the lumbar spine, we went back, got an MSA or Medicare set-aside, and the Medicare set-aside was $7,000, turned around and CNR'd the back for $10,000, and the case was done in its entirety within 6 months. Typically, that claim is a claim that would litigate for 5 or 6 years. The expenditures on the litigation side would easily be over $100,000, $200,000, and then the medical treatment exposure would be over $1 million.
So definitely a situation where you can get creative, absolutely mitigate costs, and being able to show them why this makes sense at this stage, because if you don't do this, this is what you're looking at, and that's a huge number, and ultimately made a business decision at that point.
Absolutely.
All right, and I think we kind of touched on this as we carry over from the last slide. Was there anything else you wanted to add to the indemnity-only CNRs?
So indemnity-only CNR, just briefly, it's an alternative version of a stipulated award. Essentially, what we are doing with an indemnity-only CNR is locking in the permanent disability percentage, still allowing the applicant to have future medical care for the body part. But the reason why you would do this as an employer is because possibly the applicant is still working for your company, or if the insurance carrier is still on the risk for the individual. Also, it locks in the permanent disability as far as no new and further can be filed by the applicant attorney. So if you stipulate a case by stipulation award, the applicant attorney would have up to 5 years to file a petition for new and further. And if he can produce medical evidence showing that there's been an increase in disability for the applicant, essentially the case gets reopened and they may be able to get a higher permanent disability award. If you do an indemnity-only CNR, the PD percentage is locked in and they cannot file that filing.
So you touched on this a little bit, but there's also some creative opportunities to include the Medicare set-aside. And it's essentially using it as a tool to estimate future medical care. You want to kind of elaborate a little bit on that one?
Sure. Sometimes when you don't fully know what the applicant's future medical care is, if you have some of their records, or if you have the records related to the current case and the applicant is in an age eligibility situation, or they're already on Social Security disability benefits, you can go to your MSA vendor and they can generate a report based on the last 2 years of medical history and give you a valuation for the future medical care, which will give you a basis to lead into settlement negotiations. So you can estimate the permanent disability value of the case. Future medical care is a lot more technical, and with an MSA, it gives you a lot stronger basis to present to opposing counsel and say, look, this is maybe what we've obtained through an MSA report. This is what the valuation of the future medical care would be. More recently, the trend that we've seen is a lot of carriers and self-insured employers are using evidence-based MSAs. And so what that is it's an MSA that is not going to take into the full valuation of future medical care. It'll look at the exact treatment that's been provided to date, look at the probability for continued treatment, and then we'll say essentially the future medical care is worth 10 to 13,000, whereas the traditional MSA would be 50 to 60,000. The other advantage of an evidence-based MSA is that you do not need CMS approval. And so you're not going to bear the risk of CMS coming back and saying you owe additional monies. The vendors that provide evidence-based MSAs also provide indemnification to all parties. So it's to the defense counsel, to the applicant attorney, and to the applicant that they will have no liability with CMS. And the way they do that is they require the MSA to be professionally administered by their vendor. Usually that cost is borne by the insurance carrier, but then the applicant does not have to worry about submitting any receipts or proving to Medicare that they've exhausted the medical expenses related to that body part.
What's CMS?
CMS is the Centers for Medicare. So essentially you have to look at Medicare's interest when someone is either age eligible for Medicare they're a Medicare recipient, or they are on Social Security disability for over 24 months.
So what I'm hearing in this situation is, to me, twofold. We have a dispute about the value of future medical care. Let's say that we valued it at 30. Maybe the applicant attorney values it at 60, and we are going to request a Medicare set-aside as a tool to reinforce our valuation. To say, look, applicant attorney, you said 60,000, but we completed an MSA. It's in line with our valuation. Therefore, you need to bring your valuation down. You need to meet somewhere in the middle, closer to our number, and this is the reason. I think the other tool could be where perhaps you're not getting enough settlement authority from your client, and to say, look, we've done an MSA. This might be the reason we need to maybe get another $10,000 or $15,000. It's in line with an MSA. All it is a tool to gauge it, right? Again, we're not submitting it, and you're not recommending that we submit it.
It kind of proves that
It's
the attorney's not off his rocker.
It's simply
whatever
a-
value you
and
came
it's-
up with.
Yeah,
Right.
and if we can't agree, like, look, are we going to litigate this? No, but this is how we can help bridge the gap a little bit. If here's my valuation, and it's in line with, with the Medicare set-aside. So.
It's also really, really important that the claims examiner and the defense attorney work together jointly to review the MSA very thoroughly and remove any treatment for denied body parts that are not admitted. Those should not be included in your MSA value. You want to have it limited to only the body parts that are either admitted or that you've gone to a medical legal doctor on and they have found causation. Therefore, it is going to be compensable. So, for example, if you have back, psych, sex, and sleep, and sex, psych, and sleep are denied, you want to make sure that there's no psychotropic medications included in the MSA, nothing that involves those denied body parts, only the treatment for back.
Got it.
So let's go with the paper flip, huh?
Yes.
So moving on to one that we've utilized a lot in the past, it's bulk settlement conferences, and I think the reason I like it is an opportunity to shut down a lot of claims in one sitting. And so why don't you dig into a little bit about what that means?
Sure. So typically, for example, if you have a large employer and they are using multiple defense firms, often throughout the inventory of their cases, they may have 15 or 20 cases with one applicant firm. And so it's always a good idea to have your defense firms pull a spreadsheet, or have the employer or the insurance carrier pull a spreadsheet, or the broker, and identify how many cases are with that particular applicant firm, and then try to set up a day or 2 days, depending on the volume of claims, where you go through all of those cases and you try to reach settlements on the cases. What needs to be done to facilitate that is you have to reach out to opposing counsel, give them a list of all the claims that you have together, and then ask them to set aside a day or two. Typically, it will be on Fridays because the applicant attorneys are not in court on those days, and it's a good opportunity for them to meet with their clients. Set aside a Friday or two, and then start to dive into these cases so you can settle as many as possible.
That's like Christmas come early, right?
It absolutely is.
For the applicant attorney.
Yes.
Yep. I remember we had a client where that was the first thing that we did whenever we took over the account. We brought you on board, and we identified, I think it was 15 or 20, and we settled, 70% of them.
Fantastic opportunity to shut them down. And I think, too, there's a little bit of give and take on each side. Whereas, look, normally you're drawing the line at 40. Look, for today's purposes, because we're going to get it shut down along with 8 other ones,
Right.
you might give 42.5. But at the same time, you're stuck on this number. I need you to give a little bit because we've done so on the other 4, 5, 6, 7 files. And so
The reduction of 8 or 9, 10 claims,
Absolutely.
there's a dollar amount to that.
Yes.
Right? The amount of work that goes in, litigation expenses that you're going to spend on those 8, 10 clients. So maybe you budge 15% above what you typically would, or 10% above what you typically would.
Well, and I think, too, what ultimately, Martin talked about this, a lot of these firms, they're working on volume. If you can guarantee that on one day we are going to drill down on 15 claims, and there's a very good likelihood,
15,
right, and there's a very good likelihood that you're going to shut down the vast majority of these, then that's something that they will absolutely consider, prepare for, and look forward to, quite frankly.
It's absolutely true. Definitely one of the key components to setting up any of these, again, is the legwork that you do up front, the preparation. Leading up to a bulk settlement conference, you definitely need current medical and indemnity benefit printouts so we can address any permanent disability advances that we need to take credit for, any temporary disability overpayments. You definitely want to be aware whether there's an EDD lien, what periods have been paid, because if there's any overlap between EDD and TD, again, you're going to want to assert credit for that. You don't want to miss out on that and then try to revise those documents later, because that's going to create a huge situation with the injured worker and with the applicant attorney as it reduces the value of their settlement. You also want to be aware of any Medicare or Social Security disability issues. That way you're not settling a case that you shouldn't be settling, and then any child support issues, and prepare the documents leading up to the bulk settlement conference. If a voluntary resignation is necessary, make sure you have those. Any addendum that you would typically use, have those available. A lot of times panel QME waivers, just you need to be fully prepared. The other thing is from the employer or the insurance carrier side, you need to be flexible with the settlement authority, because if you do come into a scenario and you ask the opposing counsel to set aside a day or two for this, and you're adamant in your position on every case, they will never do a bulk settlement conference with you again, because it's a waste of their time and it wasn't productive. Right. So they're definitely, like you addressed, there needs to be a give and take.
Well, I recommend a range.
Yes.
Right, per claim, you got 15 to 25,000. And then towards 15, but if you got to go through that.
And then maybe strategically start with some that are definitely going to settle right off the bat, right? Start with the low-hanging fruit, so it gets the kind of juices flowing, get the vibe going, the mojo. That's important. And get it going.
To circle back a little bit what I've touched on before, how much of it is the practicing the law and how much of it is just dealing with a guy that you run into every week. I know on the civil side, because I've sat in that room, and it's like, hey man, what's your number? How much money do you want? Right?
Yeah.
Just tell me. It may be a no, but tell me how much money you want. How much of that is workers' comp like that? I know workers' comp is more regulated compared to the civil arena, where it's, hey, you guys settle it, and then we'll think, and then it'll get approved, right? But in workers' comp, it's regulated, and then the judge has to sign off on it, and it has to be in line with the valuations and whatnot. It just seems a lot more regulated than the civil side, because I mean, we've sat in those rooms where it's like, how much money do you want? I don't know. And I'll let you know if I'm cool with it.
Yeah.
So is work comp like that or no?
No, it absolutely is. I think especially in these type of scenarios, like once you've entered into a bulk settlement conference, it tends to be a lot more negotiation and personality based as opposed to technical skills. If you have an opposing counsel that's willing to set up a bulk settlement conference with you, typically you've done business together in the past or litigated cases together in the past. And so now it's like, look, you know the valuation of the case, I know the valuation of the case. What's an equitable resolution here? Like, let's meet in the middle, or let's figure out how to get this done instead of continuing to waste time.
Just real talk, he's cooler than the guy that
won't
sign up for the bulk settlement.
Yes,
right?
He's in your fantasy football league.
Exactly.
For sure.
God, that'd be ideal. That'd be an easy settlement.
Laura, did we have any, I'm not sure, I think there may have been a few questions that popped up. Let's see if we can get them here. Let's see, does that show up on the screen? Let's see. Did you bring your bifocals today, Martin? Is that like too fun? We're gonna get to them, guys. I promise here. Let's see. Agree that settlement authority should be in place prior to depo or settlement conference. Do you not agree with blanket settlement authority?
Oh, as far as just like if any claim were to pop up, you have up to X blanket authority.
So is that the question? I think they're asking, are they proposing the question whether or not you as the attorney would prefer to have a blanket settlement authority and you dole it out as necessary, or I'm not sure how to interpret that question.
Okay, so I mean, blanket settlement authority is just usually like, hey, for any claim for employer X, we're going to give you desk authority of $15,000-$20,000. I totally agree with the commenter on there. It should be case by case. Obviously, if you have no medical or factual evidence to support an injury, if you have strong defenses, if you have strong employer documentation, you're not going to pay $10,000 or $15,000 on a claim. You're going to pay $1,000, maybe $2,500 if you're motivated enough to resolve it early on in the case. Again, a lot of what we're talking about today is when the employer or the insurance carrier is very incentivized to try to settle the case.
Yep.
Yeah, no, good point. And I think the interesting thing for both of us is before you were an attorney, you were an examiner.
Yes.
I was an examiner as well. And so at some point, we each had our own level of authority at each of the places that, that we've been. And so on that level, I like the idea of giving some autonomy to the decision makers to be able to, assess a claim and be able to relay it, appropriately. That obviously takes some trust, right? You got to earn that. You got to earn the ability to move up to 10, 15, $50, $100,000 settlement authority. And that, someone I'm sure needs to kind of, review that regularly. But no, I'm a big proponent of giving people the autonomy and the ability to assess and help get things closed. And there's some trust and confidence that goes with that. But I can definitely go along with that.
Just depends where your situation is. I mean, we have some clients where they give us authority. Right? Not solely the attorney, but the broker. We have authority.
Yeah. So
and then on that last comment regarding the MSA, and let's say you do get a low value MSA, and I think that's a great point. Thank you for bringing that up. Is if you do get a low value MSA early on in the case or towards the end of the case, you do have the option to submit that to CMS as soon as possible to lock in that value. That way it doesn't fluctuate any further. It's a really good point.
Yeah. So a couple other things that that came to mind while you were talking is, as far as finding creative ways to help facilitate settlement. If we're stuck on a number and it doesn't look like we're going to be able to get there, one of the creative things that a carrier or employer can do is waive things like permanent disability advances or total temporary disability overpayments, right? Those sometimes can be really big numbers depending on how late the reports come in or how much permanent disability has been advanced. So that might be a situation where if we're stuck on a number and we haven't been able to bridge the gap, we need to find a way. Creatively, you can offset that by saying, look, we'll waive the disability overpayments, or we'll waive any minor PD advances that have been paid, just as a way to help bring it to resolution.
Absolutely. And I think always in a settlement setting, there's psychological thresholds for the injured worker. A lot of times you have to be aware of what those are. So when you're walking into, let's say, a deposition, if the employment ended in a very hostile manner and there's bad blood between the employer and the employee, it's going to be a lot more difficult to settle a case where in a situation where you have like a mass layoff and you have a bunch of post-term filings. A lot of times those cases are more amenable to early resolution for a lower value. Also, again, the mechanism of injury and the severity of the injury.
So another question came in. Martin, where did you get that tie? I really like it.
So this is from the Raw Stress for Less collection.
I feel like we need to do some rapid fire questions to end this on a good note. Think of two real quick. Martin, what's the max number of files that you settled in one day?
4.
And they were all $10,000 under settlement authority?
No.
The answer was yes.
What sort of caseload does everybody at your firm have?
Typically between 50 to 65 files.
What is typical? You were at a larger firm before. What does a larger firm have?
I would say usually it's a combination. So usually they have between 80 and 90 active full cases, and then possibly maybe 10 to 20 lien-only type files or just open future medical care type situations.
Do you guys handle a case from soup to nuts? So case in chief, lien, subrogation, or what is an MSKW specialize in? Give us a little background on MSKW and maybe a little bit about your firm before we sign off as well.
For sure. So MSKW, Misa, Stefen, Kohler, Ward. It's Teresa Ward, Matt Kohler, Michael Misa, and myself. We all did come from a large national firm about 4 years ago. We've all had over 10 years of practice history, a lot more than that actually. And about 4 years ago, almost 4 years ago, we opened up our own firm. We really wanted to specialize in having low caseloads and being very proactive for our clients. A lot of our clients are permissively self-insured, and it's their money, or they have high deductible policies. And so they want to move these cases as quickly as possible. They expect the highest levels of customer service. And for us, we adopted the philosophy from day one that we're going to have very low caseloads, which will allow the attorneys to be super proactive. Also, what we touched on earlier is strategically assigning the defense attorney to the file based on their relationship with the judges at a venue, opposing counsel, and their familiarity with these specific issues that are being litigated. That's been significant for us. Over the last 3.5 years, our claims closure rate using that philosophy, using the low caseloads, has been 65%. That's across all of our claims, all of our inventory. That's a really good number. And I think the other benefit of having lower caseloads is it gives your attorneys good work-life balance. And so it allows them to, when they're on the job, when they're litigating your files, they're totally into it and they feel like they have that balance that gives them professional and personal satisfaction.
And they actually have the bandwidth to be able to dig into a file and not just churn and burn to the next one, right? Barely dig in, move to the next one, barely dig in, move to the next one. You guys have a young, energetic, very cool culture at MSKW. You guys are very, I would say, forward-thinking, and not only the social aspect of your work culture, but the way you handle things. I mean, we've settled claims by you texting the African attorney, right? I mean, that's something that probably at your old firm nobody even think of doing.
No, that's very true.
Because it's not a good opportunity to bill.
Yes,
absolutely.
And we always believe the philosophy is not about the billing. If you're doing really good work product, if you're diving into your files, everything will generate on its own. The most important thing is getting the results for the client, responding to emails and telephone calls as quickly as possible, and just doing your best to think of it as a team environment. One thing we didn't touch on is in those bulk settlement conferences, if you do have multiple defense firms, never be afraid to take the lead for your clients and work with those other defense firms to prepare the settlement documents, to go to bat for the client as a whole team, and to ultimately get them results. It's not going to take business away from any of the other firms. Basically, you would have 1 or 2 attorneys show up from each firm and then negotiate those cases, get them all done. Everyone goes to the board and walks through the settlements on behalf of the client, which is why we're all doing this, and they get the benefit of the result and the hard work.
How many attorneys do you guys have?
Right now we have 13 attorneys.
And what boards do you guys go to, or what's your region that you cover?
We just hired an attorney who specifically handles San Diego. So we have from San Diego all the way up to Santa Barbara.
Okay. Yes. Excellent. Just a couple questions. Favorite labor code?
Are you talking to me?
Yeah. Sure. You're talking to me. Trying to throw you off. Trying to throw you off before we shut down. Favorite labor code? Terrible question, but I'm curious.
4061, 4062.
What section? And let's see. That's. I was joking about that. That's all I've got. Want to thank you for coming in again today. I appreciate it. I think this is something that a lot of people ask us about, was how to creatively shut down claims and get settlements. So thanks again, and thanks for joining us, everybody, and look forward to the next one.